Michelle did the right thing and stayed at home with her mother. So we have just 7 of us today. Everybody will stand, and Commissioner Gelzine will lead us with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The public session minutes have been circulated. Do I hear a motion that they be approved as circulated?
So moved, Mr. Chairman.
Second.
It's been moved and second. All in favor, say aye.
Aye.
Opposed, like sign. That takes us into consideration of final action. And the first item on the agenda is complaint number 18900. But first, let me make some preliminary announcements. We are here as guests of the First District Court of Appeal, and we are asked to abide by their rules and regulations, and nothing but water is allowed in this room. And also, please, everyone, silence your cell phones. We would ask that anyone addressing the commission please speak up so that our recording microphones can pick up what you say. We also ask you to be brief and as concise as possible. We have in a number of items a relatively short agenda, but today we have some what I think could be complicated and time extending, and we want to keep everything under control. So please consider that. Pursuant to statutes, the members of the public have an opportunity. This is our public session, and so you have an opportunity to input on matters before the commission. Other than cases which we act in a quasi-judicial capacity. So there may be some of you that wish to speak up on items. And so that takes us to consideration of final action. The first item is in re Daphne Campbell, 18-090. We have before us a recommended order of the administrative law judge for the Division of Administrative Hearings, recommending a commission find the respondent violated Article 2, Section 8, Florida Constitution, and Section 112, 3134 of the Florida statutes for the 2013, 15, and 17 CE Form 6 filings, and for those violations, recommended public censure and reprimand and civil penalty of $5,000 per violation for a total of $15,000. Both the advocate and the respondent timely filed written exceptions to the recommended order, and therefore thereafter the advocate filed a response to the respondent's exceptions. The exceptions, the purpose and the full record are included in your meeting materials. We also have a draft final order by our staff which analyzes the advocates and the respondents' exceptions. I'm sure that you have all read those as they have been circulated. So we'll give the respondent and the advocate 15 minutes each for argument and rebuttal. The advocate will argue the exceptions first, then the respondent will reply. The advocate will have time for rebuttal, and commission members are free to ask questions at any time, and we'll have discussion, questions of staff, and a motion on adoption of the staff's order. I would remind you, commissioners, that under the Administrative Procedures Act, we're unable to reject or modify a finding of fact unless we determine that there is no competent substantial evidence to support the finding. And if we reject or modify conclusion, we've got to find that our substitute conclusion of law is reasonable or more reasonable than the judge's. So will the parties and their counsel please identify themselves for the record? Ms. Hadley is here. And who do we have, if anyone, representing the respondent? Thank you, sir. We'll call on you at the appropriate time. Any comments before we start? Commissioner Lesnoff?
Just a question. If we've previously disclosed a relationship at a different meeting, does that need to be disclosed again?
I don't think so. I mean, it's on the record.
Thank you.
Commissioner Wallman?
Thank you, Mr. Chair. That being said, I don't recall if I made a disclosure at the last meeting, but I served in the legislature with Ms. Campbell. It will not affect my decision-making in this proceeding.
Any further comments?
Mr. Chair, I will also disclose that my previous role, I worked with legislators, and Kathy Campbell was one of them. So,
But that will not affect your...
will not affect me.
All right, anything else?
And, Mr. Chairman, as well, I'd like my previous disclosure to be on the record in this matter, which will not affect my participation.
Okay, anybody else? Ms. Hadley, you're recognized.
May I reserve my remaining time for rebuttal?
So noted.
On November 19, 2021, the administrative law judge issued a recommended order recommending that the Florida Commission on Ethics enter a final order finding that Respondent Daphne Campbell violated Article 2, Section 8 Florida Constitution and Section 112.3144 Florida statutes on 3 separate occasions in the years 2013, 2015, and 2017. The recommended fine is $5,000 per violation for a total of $15,000 in public censure and reprimand. I respectfully request the Commission to adopt a recommended order with a few exceptions, 4 to be exact. Exceptions 1 and 2 have to do with the findings of fact, while exceptions 3 and 4 deal with the conclusions of law. The Commission may reject or modify the findings of fact if it reviews the entire record and determines that the findings of fact were not based upon competent substantial evidence or that the proceedings on which the findings were based did not comply with the essential requirements of law. In exceptions 1 and 2, these deal with a simple error. Paragraphs 4 and 5 of the recommended order indicate that Respondent was a candidate or served in District 28, while the evidence reflects that it was District 38. These paragraphs should be corrected. Regarding the next 2 exceptions, the Commission has substantive jurisdiction and can reject or modify the conclusion of law if they find the exception to be more reasonable. Exceptions 3 and 4. Both exceptions deal with the same issue, a missing liability and 2 conclusions of law. Paragraph 71 lists the inaccuracies in Respondent's 2015 form, while paragraph 72 listed inaccuracies in Respondent's 2017 form. However, both paragraphs fail to list a code enforcement lien as a liability that Respondent was required to disclose. Regarding exception 3, paragraph 71, the evidence to reflect that the code enforcement lien should have been included in the conclusion of law is provided in the following findings of fact. In finding of fact 37, it says the code enforcement lien against Respondent's Miami property remained unsatisfied at the time of the final hearing in this case. Accordingly, the lien should have been reported as a liability on Respondent's 2015 CE Form 6. In paragraph 38 of the findings of fact, it says Respondent did not disclose the code enforcement lien as a liability on her 2015 CE Form 6. Findings of fact 37 and 38 present a factual basis to include code enforcement lien as a reportable liability that Respondent failed to disclose on her 2015 form. Paragraph 71 should be amended to include a code enforcement lien as a reason Respondent's 2015 form was inaccurate. Regarding exception 4, paragraph 72, there is evidence in the record to reflect that the code enforcement lien should have been included in the conclusion of law is provided in the following findings of fact. Finding of fact 44, it says the code enforcement lien against Respondent's Miami property remained unsatisfied at the time of the final hearing in this case. Accordingly, the lien should have been reported as a liability on respondent's 2017 Form 6. In paragraph 45, it says respondent did not disclose the code enforcement lien as a liability on her 2017 Form 6. Findings of fact 44 and 45 present a factual basis to include code enforcement lien as a reportable liability that respondent failed to disclose on her 2017 form. Paragraph 72 should be amended to include a code enforcement lien as a reason respondent's 2017 form was inaccurate. Advocate respectfully requests that the Commission enter the following relief. Adopt the above amended findings of fact. Find that the amended conclusions of law are as or more reasonable than those found in the recommended order, and enter a final order and public report consistent with the above exceptions. I have reserved rebuttal time, but I stand on my written arguments for any arguments respondent may bring forward in her exceptions. Aside from exception 2, all other exceptions should be rejected as indicated in my written argument. Nothing further.
Thank you, and you have reserved time to come back. Yes, sir, you're recognized.
Good morning, member of the board. James Jean-Francois on behalf of Dr. Campbell. Well, the reason we're here today is because of alleged violations that was filed. Based on the violation that alleged that Ms. Campbell did not include certain items in the disclosure Form 6 when she ran as a House and also as a Congress and the Senate. However, we had a hearing on that. The LG, we had testimony, the witnesses, there were several witnesses. Based on the hearing, we believe that they were not substantial and competent evidence presented. Because the reason that they were not substantial and competent evidence presented, what the form alleged that Ms. Campbell failed to disclose, one, that there was a deed that was transferred. The problem with the deed that her son had filed a fraudulent deed conveying her property to a corporation, and from the corporation to himself, and from himself back to Ms. Campbell. At the time of the conveyance of that deed, Ms. Campbell, when she filed the Form 6 in 2017, she was not even aware that transaction had took place approximately a month before. And during the hearing, that there was no evidence presented that she was aware of that, her signature was indeed. The notary that was presented at the time the alleged conveyance, the notary did not testify. In addition to that, the two witnesses on the deed was not present. So there was alleged that she incorrectly listed that property in the form where she did not own the property. That is incorrect. There is no substantial competent evidence. That's one of the information. In addition to that, what was listed also that as far as the code enforcement, there was a code enforcement that she was fighting with Miami-Dade for several years, and the code enforcement, and in fact, when she read the form, she believed that it says that if it was not reduced to a judgment, it should not be included. Therefore, the code enforcement was not included. In addition to that, as one of the alleged violations that she failed to disclose that a federal tax lien, and the form itself clearly stated that a federal tax lien, unless it's reduced to judgment, it should not have been included in the form, and she did not. In fact, the administrative judge Lord did find that that is the fact, and it is under Form 6 that she should not have disclosed it. It's not required to disclose it. And those are the violations that. In addition to that violation, what we have now, they also stated that Ms. Daphne Campbell failed to listed certain mortgages that was on the property. The mortgage were basically bail bond mortgages. Under the law, a bail bond mortgages are what we call conditional mortgage. A conditional mortgage, basically, it does not rise unless there is a default. So what we have in this case now, at the time of the bond was taken, that she and her husband jointly pledged the house, and then they give a conditional mortgage and a note. So the conditional mortgage only come to effect if and only when the property, there was a default that the son didn't pay the mortgage. So in fact, in the reasons that what we have, when you recorded the mortgage, actually, for that same reason, the mortgage is you only pay documentary tax stamp on the mortgage, and you do not pay intangible tax. In fact, there was a case law on that. It talked about that no intangible personal property tax is due upon recording in light of the second nature of liability of mortgage, which would arise only after a default under the bond referred herein. Cited West Flagler Association Ltd. versus Department of Revenue, citation 633 Southern 2nd 555 3rd DCA 1914. So that itself, the mortgage itself, is contingent upon a default. So in fact, on Form 6, on the back under instruction of the Form 6, it talks about contingent liability need not require to be included. And also, during the hearing, the bailsman testified that the mortgage was satisfied. In fact, the bail bonds could not even tell how much was the value that was left on the note, if any, because the form also required that if the amount is less than $1,000, you do not have to disclose it. And again, she did not disclose it because the bond is, the mortgage is basically what we know in going back in property law. The mortgage follow the note. The mortgage will only come to effect if there is a default in the note. If there is no default in the note, the mortgage will just sit there. It's a lien, but this one is a contingent mortgage. Now, as to the note, when Mr. Brenman, the bondsman, testified during the hearing, he testified that the mortgage was satisfied. He did not know he testified that Ms. Campbell did not have to pay for the mortgage. Someone else paid on the loan for the bond. And also, based on his testimony, again, the administrative law judge concluded that there is no substantial evidence that the amount that was owed on the bond was $1,000 or more, because he did not even know how much was owed on the note, if there was any amount that was owed on the note. And now Ms. Campbell, again, as a contingent mortgage, and again, it was not required to list it in the disclosure. So, in other words, all of this violation alleged that she failed to disclose the mortgage, and the mortgage was, again, contingent mortgage, not required. She failed to disclose the property that she actually included a property that she did not own, where she actually owned the property. The question was that why she didn't prosecute her son for doing the fraud. Again, within less than a month or two, when this was brought to her attention, I, on behalf of Ms. Campbell, sent a letter to the notary and her son. Within a month or two, the property was reconveyed back to her. So that information, because when she filed the form, I believe was in May 2017, and she discovered in June, that's where the alleged violation say, hey, you listed a property in your mortgage. Given all this information that took place during the hearing, and then we believe that there was basically no substantial evidence that was presented to show that Ms. Campbell did not complete the form properly. And then in addition to that, then another issue that was also raised, there was a contractor that placed a lien on the property. The contractor was Pierre Raymond. Pierre Raymond testified during the hearing that he only had one conversation with Ms. Campbell at the beginning for her to sign the notice of commencement. This property that he was repairing was because of a hurricane damage. So they had filed a hurricane claim, so he was waiting to get the proceeds for the hurricane. So he dealt with Ms. Campbell's son. So he only dealt with her once for her to sign the notice of commencement. Once she signed the notice of commencement, then he dealt with her son. So in the process that he recorded a construction lien for $41,000, which Ms. Campbell was not even aware there was a construction lien on the property. And then he testified that once the insurance case was settled, he received the money, then he had removed the lien. All of this information was taken by, the investigation was done by, I believe, then candidate, Mr. Pizzo, in attempted to unseat Mr. Campbell for District 38. At that time, what he had done, he had hired Ms. Campbell, prior campaign manager, Mr. Charlie, to work for him in order to get dirt. So in the process of that, this is basically a work done by Mr. Pizzo in attempted to, like I said, to unseat Ms. Campbell, which I guess it works for him. So now he's asking the commission to go along with his dirt. And even though there was not substantial evidence presented during the hearing, in fact, the report presented was basically full of hearsay. Yet, the investigator, Mr. Travis, who conducted the alleged investigation, did not even testify as a witness. So what we have a lot of hearsay information that, based on the report, that Mr. Travis alleged to interview several people. They say this, they say that, they say this. Yet, during the main hearing, he did not testify, so to present this credible and substantial evidence that he relied on the report itself. So this is why when we filed the exception, and the exception was filed because there was no substantial evidence. In fact, that the administrative judge, again, the fine that she had is basically $5,000 for each violation, in addition to that reprimand, in addition to that censure. So this is basically, we have a miscarriage of justice. It's basically trying to kill a fly with a bazooka. That is basically what's going on. I'm asking the commission to look at it. You have the authority to reject and modify the report based on the evidence, and by looking at it, you look at the testimony and the evidence in the report itself, you can tell that there was not substantial, credible evidence and beyond clear and convincing evidence that based on what the IJ wrote. So we're not asking you to weigh the evidence. I'm asking you to look at the evidence itself and look at it, read the report, and then determine that there was not clear and substantial evidence presented at the hearing, not to weigh it. So therefore that, again, you have the authority to modify the conclusion of law and also as to the proposed finding. So based on that, I ask you to reject the report.
Thank you, sir. Are there
Yes.
questions of any of the members? None appearing, thank you. And Ms. Hadley, you're recognized for your additional time.
Just to hit on a few points from Mr. Attorney Francois' statements. In my response, I listed, on page 5, I listed the instructions for the liabilities. And it states that you're supposed to list the name and address of each creditor to whom you're indebted on the reporting date chosen for your net worth. It states liabilities includes accounts payable, notes payable, interest payable, debts or obligations to governmental entities other than taxes, except when the taxes have been reduced to a judgment, and judgments against you. It also states what a contingent liability is. A contingent liability is one that will become an actual liability only when one or more future events occur or fail to occur, such as when you are liable as a partner for partnership debts, or when you're liable as a guarantor, surety, or endorser on a promissory note. If you're a co-maker on a note and has signed as being joint and liable or joint and severably liable, then this is not a contingent liability. The mortgage note in this matter, not mortgage, the mortgage note that the respondent signed along with her husband, that's not a contingent liability. That will require an intervening act before disclosure. The Commission on Ethics has opined on this, and it states in Commission Opinion 8640 that the Commission deferred to the general law governing negotiable instruments and adopted the reasoning that a guarantor, surety, or endorser is liable on a debt only upon a third person failing to carry out an obligation to make a payment. In this case, she was liable just as her husband was liable on that mortgage note. She had a monthly payment to make regardless if she made it. That's the reason it was a debt. In the court, ALJ also recognized this. That's why the mortgage note is only on, like, the 2013 form. I think it's on the 2015 form. It's not listed as an accuracy on her 2017 form. The court recognized all this. And another factor, the federal tax lien. The ALJ also recognized that no, it wasn't required to be disclosed. However, it was required to be used to determine an accurate net worth. So that's listed in the recommended order. The court recognized all that as well. Regarding the certain witnesses not being called, neither party called them. The notary wasn't called, she was available. The witnesses weren't called, they were available. However, just because the investigator wasn't called isn't a factor in this, because we had other witnesses who were able to testify to the facts, which is what occurred in this case. Frankly, the respondent is incorrect on a lot of things he said up here, and I hope that once you've reviewed, or I know you've reviewed my recommendation or my response to his exceptions, you will see how it was laid out. Now, I don't want to take your time by reading it to you. Are there any questions for me?
Are there questions of the advocate?
Mr. Chairman, I was very well informed by Ms. Clanky's general counsel opinion on this matter, and I was wondering if you will entertain her being able to briefly review her memorandum, which weighed out the exceptions made by the advocate and the exceptions made by the respondent.
Yes, we can do that.
Indeed. In the instant matter, there is a memorandum and a draft final order for your consideration. Why? Because 120.57 subsection 1K provides that an explicit ruling on each exception must be made in an analysis of the recommended order which you have before you. In the instant case, the advocate has filed timely 4 exceptions, and we are recommending that the Commission, for the reasons set forth in this draft analysis grant the 4 exceptions. The first 2 are for the correction of Scrivener's error, and the latter 2 pertain to a conclusion of law. As we know, under the standard of 120.57, conclusions of law may be rejected or modified by an agency, but must state with particularity why the substituted conclusion or interpretation is more reasonable than that of the ALJ. And we believe that that is set forth in the draft order for your contemplation. The respondent's exceptions were also timely filed, and there are 11. We are recommending in the draft before you that 2 of them be granted, those pertaining to the correction of the Scrivener's errors, and the remaining exceptions be denied. Some of the exceptions, including exceptions 1 and 3 through 11, are of that ilk, and they pertain both to conclusions of law and findings of fact. We believe that the findings of fact reached by the ALJ are supported by competent, substantial evidence, and that is the basis for the recommendation of their denial. And with regard to the conclusions of law, they are each incrementally and meticulously addressed in the draft before you, and we are recommending rejection thereof. In addition, we are recommending that the penalty that was proffered by the administrative law judge in her recommended order should also be ratified by this agency, as it is in accordance with our statutory authority in section 112.317, and it is merited by the 3 years, 2013, 2015, and 2017, wherein the inaccuracies appear on the Form 6 filings.
Any further questions? Mr. Maggs?
I don't know who I would ask this of, but I'm assuming that at this administrative hearing that the rules of evidence obviously were followed. I've heard a statement from the respondent's attorney that nothing but hearsay was admitted. I don't think hearsay is admissible unless there's an exception. Were the rules followed in this, or should the respondent be in the First District Court of Appeal because there was no rules of evidence followed? I guess that's kind of a statement and a question that maybe an advocate can respond to.
The rules of evidence are followed. However, in administrative hearings, you can use hearsay if it's substantiated. However, with that being said, there were witnesses who were able to testify with firsthand knowledge, and there are also documents that were substantiated with other evidence in this case.
Correct. The actual statutory language of the provision that's applicable is 120.57, Section 1C, which provides that hearsay evidence may be used for the purposes of supplementing or explaining other evidence and is thus admissible regardless of whether it would be admissible in a civil court of law.
Mr. Wallman?
Thank you, Mr. Chair. Actually, I just want to confirm that I was schooled in this last meeting by Ms. Clanky when I made a statement about hearsay, so she's very consistent, and I appreciate it.
That she is. All right, are there further questions? All right, let me tell you what we have to do. We must vote on the exceptions, and we must vote on whether to accept the findings and conclusions that are submitted by the administrative law judge, and whether any changes should be made. If any changes are made, the reasons must meet the announced criteria and should be explained by the member who wants to make the changes, and the motion can encompass all of the recommended order, or we can break it down into findings of fact, conclusions of law, and penalty, and so forth. However, the commission can handle all of this by adopting the staff's final order, which addresses all exceptions, findings, and conclusions. So it is your choice, commissioners, whether you want to break this down or you want to handle it, again, what has been recommended by the staff's prepared order.
I'm sorry, I yield to Mr. Meigs.
I would make a motion that we adopt the staff recommended order.
All right, we have a motion. Is there a second?
Second.
Commissioner Lesnoff seconds.
Mr. Chairman.
Commissioner Gates.
Mr. Chairman, I'm going to try to audition an amendment to Mr. Megg's motion. And the amendment would have to do solely with the penalties. The whole purpose of public disclosure of assets, liabilities, and net worth is so that candidates for office and office holders disclose who they owe, what they owe, and that the public has an opportunity, therefore, to make determinations based on all of that when they cast their votes. And Representative Campbell, if there was a PERT chart of all the things that you shouldn't do with respect to public disclosure of assets and liabilities, she's checked them all. And I won't take the commission's time, and the chair's, I won't beg his indulgence to go through that list. I'm happy to do it if you want. But she's filled in every blank of everything that you shouldn't do and every circumstance in which she did not tell the truth. And the findings of fact, as presented by the administrative law judge, are not disputed. Those findings of fact lead us to the conclusion that we have here a public official who flagrantly, consistently, and purposefully violated open government and public disclosure laws. Now, there's a proposal before us, now incorporated in Commissioner Megg's motion, that we agree to a public censure and a reprimand, which is entirely appropriate, and a fine of $5,000 for each of the three specific charges that are made or violations that have been found. I don't know what you have to do in the world of public disclosure to do much worse than Representative Campbell did. Maybe there are some things you can do in this category of open government that are worse, but I don't know what they exactly are. She lied about everything, failed to disclose everything that she needed to. We have set, in prior cases, Mr. Chairman, we have discussed the message that needs to be sent or is sent by this commission when we impose penalties. We are creating a record, we're setting precedents, we're establishing standards within the law every time we set a penalty. And this should not be the cost of doing business as a public official who fails to tell the truth on and on, year after year, circumstance after circumstance. So consequently, my amendment to Commissioner Megg's motion, which I certainly support in its entirety except for the penalty, would be that the penalty ought to be increased. I'd like to increase it a whole lot, but I am trying to be sensitive to precedents that we've set in the past. So I'd like to increase it to $7,500 per instance instead of $5,000. And that is my amendment, Mr. Chairman.
Thank you, Commissioner. Commissioner Meggs, what's your response? Is that something you would accept to your?
I would accept that.
All right, without objection,
Enthusiastic.
so we don't have to vote on the
Still need a second.
Gates amendment. If you accept that as an amendment to your motion, then we'll do that. Commissioner Waldman, do you have something?
I was
to
just
say?
going to say, he then just needs to either make an amendment to his, or we have to vote, I have to get a second to his amendment on this, unless he amends his motion.
Well, I think what Commissioner Meggs is saying is he would amend his motion to include Commissioner Gates' suggestion. So without objection, show that done. Now, is there discussion on,
Now you need a second to his amendment, second to his motion that he just.
and you're
amended.
seconding?
I'll second his motion, but
Okay, all right, so we have a second to the now amended motion. Is there discussion? Commissioner Lesnoff?
I have a question. Are there additional criteria that we have to prove up when we are changing the penalty from the recommendation of the administrative law judge? Because I recall we had done this before, but there was some substantiation we had to put on the record.
I don't believe so, but Caroline, would you
Yes.
give us your opinion?
The provisions of 120.571L control in the penalty analysis, and it provides that an agency may reduce or increase a recommended penalty, but must articulate reasons with particularity regarding such reduction or increase, and, if possible, cite record evidence. The articulation with regard to the incremental volume of inaccuracies may be indicative of such an articulation. But the law does afford you with agencies with the ability to increase the recommended penalty and requires an articulation with regard to such reduction or increase.
Mr. Chairman,
Commissioner Gates?
I would ask the General Counsel, would it be necessary, therefore, or advisable to place in the record of this hearing a short but complete list of those particular reasons?
The reasons can be reflected in the draft final order if approved as modified, with the articulation regarding the basis of the increase. As you've just, we're obviously recording this, and so we will go back in the recording to scrutinize the basis for that.
Mr. Chairman, I guess my question is, have I done enough, or do you need more?
I believe so. I believe so.
All right. Thank you, Mr. Chairman.
All right. Now, is there discussion on the motion?
Only for clarification, so, may I, Chair? The final sentence on the bottom of page 24 is now 22.5 as the penalty. Everything else in the recommended order stays the same.
That's correct. The portion that's entitled disposition is going to be made more robust by virtue of the articulation that was made here today and the penalty analysis that became part of the motion itself.
Further questions or discussion? Commissioner Waldman?
thank you, Mr. Chair, and I appreciate the suggested amendment to Commissioner Megg's motion, because I do believe that it is our responsibility to make the fines appropriate towards what's taken place. I agree factually with what Commissioner Gates has stated. I think that's true. I think when you see over and over and over again repeated violations, we need to hold people accountable. And as we've talked about previously, if we're going to go to the legislature and say, please give us the power to increase fines, we need to increase them ourselves at this stage to show that they're warranted in the future. Thank you.
Thank you. Further questions? And I'll call for the question. All in favor, say aye.
Aye.
All opposed? Show it passing unanimously. All right, the next item is consideration of final action, pre-probable cause joint stipulation, complaint number 21-162 in Ray Cynthia Stewart. Will the parties or their counsel please identify themselves? Ms. Hadley, of course. Is there anyone here for Ms. Stewart? Let me state, just for the record, that Ms. Stewart is a good friend of mine. She is the clerk of the court in my local court, but that will have absolutely no bearing on my voting in this matter. Any other statements by anybody? We've got a, I'm sorry.
Also, Ms. Stewart, when she was a school board member, I had the privilege of working with her, but it shouldn't impact my ability to vote on this matter.
All right, thank you. We've got a proposed pre-probable cause stipulation between the commission advocate and the respondent. After considering all the materials and presentations, we can vote to approve or reject the stipulation, as this is a pre-probable cause stipulation. If the stipulation is rejected, it will go immediately to the probable cause determination. And complainants have the right to respond in writing to proposed stipulations. A written response was filed by the complainant on February 16th, 2022, and that was provided to you via email on February 23. Ms. Hadley, you are recognized to make a presentation.
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that she failed to accurately file 2019 and 2019 CE Form 6s in violation of Article 2, Section 8, Florida Constitution, and Section 112.3144. Respondent filed a CE Form 6X amendment to full and public disclosure of financial interest for both years, 2019 and 2020. Historically, the Commission, with pre-probable cause stipulations, have been consistent with a fine for this type of violation, which is the failure to list the products in a brokerage account. The respondent and I respectfully ask for the Commission to accept the respondent's stipulation that she violated the aforementioned Code of Ethics and recommended a total civil penalty of $1,000.
Are there questions of the advocate? None appearing. We are here to vote on the stipulation, and this probable cause determination is a conclusion of the preliminary investigation, and I will entertain a motion from a member of the commission.
I move to approve the advocate's recommendation, the joint stipulation.
Is there a second?
Second.
Is there discussion? All in favor say yes.
Yes.
Aye.
All in favor, no. Show it passing unanimously. All right, the next item is a joint stipulation, again, Colleen Riley. Will the parties identify themselves? We have our advocate, Elizabeth Miller. No one is on the other side. And we have before us a post-probable cause stipulation between the commission advocate and the respondent. And after Ms. Miller concludes, we can discuss it, and then we will proceed to vote on this joint stipulation. Ms.
Thank you,
Miller.
Commissioners. Elizabeth Miller, advocate for the Commission. This is a joint stipulation for a violation of misuse of public office. The facts of the report, the facts in the report of investigation were admitted by the respondent, and the parties have agreed to a public censure and reprimand and a civil penalty of $3,500. We ask that you adopt the joint stipulation. Thank you.
Are there questions of Mrs. Miller?
Yes.
Commissioner Lesnall.
Just in reading this case, there was large sums involved. Were those funds paid back?
Through the chair, absolutely, they were paid back, and she paid the money back immediately.
Thank you.
Are there further questions of the advocate?
Mr. Chairman.
Commissioner Gates.
Thank you, Mr. Chairman. Question for the advocate, and follows Commissioner Lesnoff's line of questioning. What triggered the payment back of these large sums? Was it a finding by an outside entity? Was it a voluntary admission? What triggered the payment?
Again, through the chair, no, it was a finding from an outside agency. There had been a complaint filed with the interim clerk for the courts. Riley had served as the interim clerk of the courts, and she was replaced by Mr. Fernandez. A complaint from some of the other employees went to Mr. Fernandez, who then got in touch with FDLE. They did an investigation. And this case went to the state attorney, Jeff Ashton, and he declined to prosecute. And we got the case afterwards.
Mr. Chairman.
Commissioner Gates.
Thank you, Mr. Chairman. So we have here not someone who discovered that they had made a mistake or discovered that they had done something wrong and then came forward. We have someone who was found out through an investigation involving the state attorney. What was the scope of this matter financially? How much money are we talking about?
Hundreds of thousands of dollars. When the interim clerk came in, if I may, when the interim clerk came in after the death of the clerk of the court, Riley was appointed as interim. There was a general counsel for the clerk of the court by the name of Stephen Carter. He was also a former judge. He was, if you will, the mastermind behind this. He went to Riley and said, we're contract employees. Let's say that our contracts have been nullified due to the death of the clerk, and let's get all the severance pay, and then we'll remain employed. Those are the underlying facts.
Mr. Chairman.
Commissioner.
Hundreds of thousands of dollars?
Yes, sir, in severance, sick leave, and annual leave.
And the cost of doing business here, the cost of being caught in misusing her public position in clear violation of the language of Amendment 12. The cost of doing business is $3,500. Why $3,500? And of course, where is the former judge?
Thank you. The former judge was prosecuted by me in 2016. It was a 2-day hearing. After the hearing, we won. The court found a violation and issued or recommended a penalty of $0 with only a public censure and reprimand. His reasoning was that Carter had returned all the money. He had suffered enough. They got a lot of bad press. That was enough. I came back to the commission with an exception, asked for $10,000. You granted it, and the governor imposed it, and Carter paid it.
Mr. Chairman.
Commissioner.
Thank you, Mr. Chairman. Why then, unless you want to draw some distinction between the activities of Ms. Riley and the former judge, why then are you proposing a civil penalty of $3,500 when you asked for and got a penalty of $10,000 on the former judge who was a party to this gross misuse of public office?
Through the chair. Yes, sir, I agree. It was a gross misuse of office. The distinction that I make is that Riley was new to the position. That doesn't make it right. She had never been a political figure prior to this. The former judge was the lawyer for the office. He was, as I stated, the mastermind behind this, got her involved in this. Now, she did have to go through with it. But with Carter, we went to a 2-day hearing. Riley does not want a hearing. I took that into consideration also.
Mr. Chairman, I hate to sound like a one-trick pony here, but I'm troubled by what the advocate has explained to us as a misuse of public position, obtaining benefit that was illegal, involving hundreds of thousands of dollars, being caught not having come forward, and the cost of this doing business here is $3,500. when the partner in crime paid $10,000. I'd like to ask, Mr. Chairman, for the comments of my fellow commissioners. I don't want to be out of line with the commission's thinking in this matter, but I'm contemplating offering an amendment, which you might imagine the content of that amendment. But I'd like to ask, Mr. Chairman, if we might hear from my fellow commissioners to see if I just got off on the wrong side of the bed this morning.
No, not at all.
Well, let me comment on that, Commissioner Gates, by first saying you may be a one-trick pony, but you're on the right horse. You know, I share your concerns that we as a commission have got to put some teeth, and it's, you know, if like the maximum penalty for speeding on the highway was $25, I think probably fewer people would observe speed laws. And
my life would be a lot simpler, Mr. Chairman.
I think that's where you are. But let me explain where we are, and what our options are. What we have here is a joint stipulation, and Caroline, correct me if I'm wrong, but we have a joint stipulation. We really can't amend it as you did in the two cases before. It was a final action, and you amended it. This is a stipulation by all parties, and the other side is not here. And so our options are to accept the joint stipulation or to reject the joint stipulation. And then it would come back to us in a probable cause hearing, and we could do whatever we want at that time. And would you agree with that, Caroline?
If it were to be rejected, if the stipulation before you were to be rejected, it would go back to DOA, whereupon a hearing could transpire, or the parties could renegotiate in the interim and come to a different resolution for your contemplation.
But, Mr. Chairman, we've had a probable cause hearing, I believe. Have we not, sir?
Okay.
But it would be, I'm sorry, a full evidentiary hearing, rather? Yes.
Well, to get the matter before us to be voted up or down, I would move that we reject the joint stipulation and that we direct our staff to negotiate a different penalty in the amount of $10,000.
Yep, I second that.
All right, we have a motion and a second. Do we have any discussion?
Yes, sir. I have a quick question.
Yes, sir.
This occurred in 2015. It was brought to us April 6, 2015, and now we're in 2020. Now I feel like Commissioner Gates asking why is it so delayed? Why is this now coming before us? Now in Orange County, there's been, what, a minimum of 2 or 3 new clerk of courts. Jeffrey Ashton, who's the state attorney, is now a judge, and so many of this, the time has gone by. So help me understand the delay of why this is now coming for us.
Through the chair. Yes, sir, that's an excellent question. And I can understand how this looks like the glass is half full. However, I see this as the glass, or the glass being half empty. I see it as the glass as being half full. Here's why the delay. First, I prosecuted her cohort, Stephen Carter. Sometime after that, she went missing. Her attorney could not find her. Attorney is an Orlando attorney, Amy Tingley. She could not find her. And she said she would look for her. To my knowledge, she never found her. At least she never told me she found her. So I called the attorney and said, I'm going to send it to DOA. This was in 2021. I'm going to send it to DOA. She said, I'm resigning. I have had no contact with this woman. So through perseverance, I tracked her down. Now, in the meantime, she had remarried, she had changed her last name, and she had moved to Texas. So I found her, I called her, I said, we're going to a hearing, and miraculously, she rehired Amy Tingley in Orlando, who called me and we negotiated. So that's why it's taken so long.
Mr. Chair, one more question.
Commissioner Guzine.
In your previous explanation, you mentioned that the governor's office rejected the higher amount. Was it this current administration or was that the previous administration?
I'm sorry, I didn't, if I said that, it was wrong. The governor issued an executive order for $10,000, public censure and reprimand also, and Mr. Carter did pay that. It was the administrative law judge who said that Mr. Carter had suffered enough and would recommend a penalty of $0 with a public censure and reprimand.
Commissioner Carvajal.
Just for clarification on the motion, I think as presented, it was rejecting the joint stipulation only with the condition that it come back with $10,000 as it was a
Mr. Chairman?
I don't
Yes, sir.
think, was that your intention?
That was my
the
intention.
motion, and I'm just wondering if that's a legitimate motion that we can consider.
The rejection is feasible and absolutely within your purview, but the direction of the monetary amount is not possible.
So
We can.
just to put us in the proper posture, I would recommend that the motion be amended properly to get us up or down only. And the intent is clear.
Yeah, I think what
Correct.
Commissioner Gates was saying was, you know, we can't amend the following, the final order. We accept it or reject it. But since this is a joint stipulation, we can certainly transmit to the parties that if you want to come back with a joint stipulation with a $10,000 penalty, the commission is inclined to accept it. If you're not willing to do that, then it would go back to DOA.
Yes, the vote would be to theoretically reject it. The motion would be to reject it, and you're clear in your communication with respect to the advocate regarding your thoughts with respect to further negotiations, should they occur.
That's
Right.
exactly what I meant to say.
All right. Is there any discussion on the motion as now clarified, which just simply says, we reject the joint stipulation? Is there any discussion? All right, I'm going to call for a vote. All in favor, say aye. Aye. All in favor, say nay. Show it unanimously adopted. All right, that takes us to the next item, which is a consideration of final action in Ray Gabriel Garcia 20-144. Will the parties or their counsel please identify themselves? We have Ms. Miller as the advocate. Is anybody here for the respondent?
No, sir.
All right. Ms. Miller, you are recognized to proceed. What we have is a post-probable cause stipulation between the commission advocate and the respondent, and Ms. Miller will explain this.
Thank you. Mr. Garcia ran for the Florida House of Representatives. When he was a candidate, he filed a 2019 CE Form 6. He didn't subtract his liabilities from his assets, which made his net worth just what his assets were. He admitted the allegation in the joint stipulation. He's agreed to pay a $500 civil penalty. Thank you.
Are there questions of the advocate? Is there a
Question.
Commissioner Waldman?
Thank you, Mr. Chair. Did he list his liabilities, though, on that form?
Yes, sir.
So the numbers were there, and somebody could have found out what it was if they had done the work, because you list your assets plus it. So I guess
That's
assets
correct.
were listed twice, is probably.
That's correct. He just took the number of his assets and put it in his net worth without taking into account his liabilities.
Further comments or questions? None appearing. Do I hear a motion?
Move to approve the joint stipulation.
Thank you, Commissioner Lesloff. Do I hear a second?
Second.
Second by Commissioner Carvajal. Any discussion? All in favor, say yay.
Aye.
All in favor, nay. Show that unanimously adopted. That takes us to the next item, which is N. Ray Dale V.C. Holness, case number 21-093. Do we have anyone?
Yes, Mr. Chairman, I'm here. I was on the attorney for Commissioner Holness.
Thank you. We'll call upon you at the appropriate time. Ms. Miller, you're recognized. I'm sorry.
Chair, I got a disclosure. As I mentioned during the previous meeting, prior to the commissioner becoming the elected, he ran an insurance agency and allowed my little sister to be an intern in his office. So just want to disclose that, and it won't impact my ability to hear vote on this case.
Commissioner Allman?
Thank you, Mr. Chair. Just as a disclosure, I know Mr. Holness, he's a Broward County, former Broward County Commissioner, and will not impact my decision-making in this matter.
Anyone else? Ms. Miller, you're recognized.
Thank you. Elizabeth Miller, advocate for the commission. Mr. Holness serves on the Broward County Commission. This matter involves 4 years of his CE Form 6s. That would be 2016 through 2019. The allegation is that he failed to disclose income from 2 corporations, and he failed to disclose the secondary sources of income from those 2 corporations. An investigation took place. It was found that he did not have income in those 2 corporations. That was not a violation. However, he did not disclose rental property and the rents that he received from that. He did amend his form, and I asked him to add more information. He cooperated, was happy to do that, and did it very timely after I asked. I believe that the joint stipulation correctly reflects what the investigation revealed, what Mr. Holness signed on his sworn statement, CE Form 6, and I ask that you adopt it. He has alleged that, or he has agreed to admit the facts, and it's $2,500 per valuation, per allegation, for a total of $1,000. $250. I knew that didn't sound right. $250 for a total of $1,000.
Are there questions
you.
of the advocate?
Mr. Chairman, a quick question.
Yes.
And perhaps the advocate or the investigator could answer this. The commission received and was circulated among members of the commission as part of the record a communication, subsequent communication from the complainant indicating that the investigation was incomplete as to the earnings from these 2 real estate corporations. So my question either to the advocate or the investigator, or perhaps both, is, was our investigation complete as to the earnings from these 2 corporations? And were all of the sources of information that we could rely upon, tax returns and that sort of thing, reviewed to ascertain that there indeed were no earnings?
If I may respond, I believe the investigation was very complete. The investigator had all the information, in my opinion, and Mr. Holness did sign the form under oath. We have no reason to believe that he perjured himself. The allegations made by the complainant would require sheer speculation on our part based on the fact we have no information, gathered no information that Mr. Holness was not being accurate and honest on his form. And I would also like to say that some of his assertions in what he wrote to the commission are inaccurate, especially as they pertain to my conversation with him.
Thank you, Mr. Chairman.
Are there further questions? Thank you, Ms. Miller.
Thank you.
Mr. Austinott?
Thank you, Mr. Chairman. First of all, I want to thank the Ethics Commission staff for working with me and my client to resolve this matter.
As Commissioner Gatz indicate, we understand the purpose of public disclosure laws. My client and myself, who have represented local government officials for the past 20 years, we respect the law, the disclosure law. We have the utmost respect. And we agree 100% with the recommendation of staff. If the commission have any questions from me, I'm willing to answer, but we support staff recommendation.
Thank you, sir, for your forthrightness. Are there questions of members?
Thank you.
Thank you, sir. And Ms. Miller, you didn't reserve any time?
No, sir.
All right. Are there questions or comments by members of the commission? Is there a motion?
I guess I do. Mr.
Commissioner
Chair.
Waldman.
I'm certainly in favor of joint stipulations where we can get them. But I like to be consistent with when we do them. And just in this today, we're not being consistent with what we did previously. We had a pre-probable cause stipulation with some similar types of disclosure issues, and yet we entered into, that was $500 per incident. Then we had one post-probable cause, and we increased that to $7,500. And I'm just concerned that we're not being consistent. I praise Ms. Clanky for being consistent in the advice she's given to us, and I just don't see the consistency here. I mean, it doesn't seem right to me. That's the end of my comments.
All right. Further comments?
Mr. Chairman,
Commissioner Gates.
I think Representative Waldman raises a good question, and I think we ought to have, you know, in the record of our proceeding, a statement by the advocate as to why you drew the distinction between this case and the other cases that we've heard today, and why you're recommending the penalty that you're recommending in this joint stipulation as compared to those that you heard previously in today's proceeding. Could you answer Representative Waldman's concern, please?
Absolutely. Through the chair. What goes into a joint stipulation, in my opinion, is whether the party is cooperative, the severity of the violation, how soon someone will enter into a stipulation. If they drag it out, it should be a little bit more, just all kinds of factors. But it is a negotiation with generally another attorney.
Further questions of Ms. Miller? Mr. Waldman?
Dude, I think.
Oh, okay.
Leslie.
I think that each situation is different, and like we've seen today, can be extremely different with respect to, I know an intent is not necessarily a factor in these types of cases in determining probable cause, but perhaps may go into part of the thinking on what ultimate penalties are. And so I think we have seen extremes with respect to disregard for this law, to the other extreme of what was probably an unintentional error, and that those differences ought to be reflected in what's negotiated. Certainly, I understand when you get to differences of a few $100s that other factors are at play, but the severity and the obstruction of transparency, I think, are the key issues why we should have some very severe penalties and others that are less so. And I think we've seen that today.
Okay.
Mr. Chair, and I couldn't agree more with you. I mean, I think that's correct. And so I then looked at it. This certainly does not rise to the Daphne Campbell level. It doesn't rise to the issue of $10,000 per violation. But we had a pre-probable cause in the Stewart matter where she agreed to everything, and all she did, she listed her correct net worth. The only thing she didn't do was list out the specific holdings that she had. So she did everything she was supposed to except listing that. So everybody knew how much money she had, how much she made. And we agreed to $500 at a pre-probable cause stipulation. So she cooperated more than anybody at this point. So here we have somebody who went to probable cause, and if I'm correct, maybe I believe we had a probable cause, and we're going at $250 for 4 violations, each one, where the other was just 1 violation. So that doesn't seem consistent to me, and that's all. And I'm not proposing a specific number right now. I'm positing that to the commission at this point to think about, because I'd like there to be some consistency, and I'd like us to have some teeth at this level. When people come here, they know that we're serious.
Further comments? Is there a motion on the matter before us?
I'll move to accept the joint stipulation as presented.
Commissioner Carbajal, is there a second? Commissioner Waldman? Okay.
I'll second it.
I'm sorry?
I will
Oh, okay.
reluctantly second.
Okay. All right, is there a discussion?
At this point.
Commissioner Waldman?
So at this point, I'd like to present an amendment to the motion, and I'd like to move that I guess it's not an amendment because I remember what this is now. So this is, we have to reject it because I do not believe that that $250 per violation is sufficient. I think that this is much more in the line of something that should be in a $500 to $1,500 per violation. And I would look to reject it with the direction to Ms. Miller to go back and see what she can negotiate or not.
Are you making that as a motion?
No, I guess that's, I realized after I looking to amend it, that my motion is actually in opposition, and it would be a vote no on accepting the.
Okay.
Mr. Chairman, parliamentary inquiry.
Yes, sir.
So if one were to agree with Representative Waldman, one would vote no on the pending motion, and if one were to disagree with Representative Waldman, one would vote yes. Is that correct, sir?
That is correct, and if
Or
the...
agree with Commissioner
I'm sorry.
Carbajal.
Absolutely. Absolutely.
All right.
Absolutely.
Well, the answer is it's an up or down because it's a joint stipulation, and this is kind of back where we were a couple of cases before. We can reject it and see if the parties want to negotiate a different penalty and bring it back to us with another joint stipulation, or if they're unable to come to an agreement, then it would simply go back for hearing.
So, did you have a question before I ask mine?
For debate,
For debate.
whenever ready. Go ahead.
Mr. Chair, is there an opportunity, since unlike the previous case where both parties wasn't present, both parties are present now, is there an opportunity for them to go out and then come back? Or does this if it gets rejected, they would have to come back the next meeting in 6 weeks from now? That's the question.
Well, that's certainly an option. The respondent and the respondent's counsel are here. Certainly, Mr. Ottenott, if you want to say anything, I'd be glad to entertain you.
My motion first.
Yes. Yeah.
Correct.
Yeah.
In the instant case, this analysis is governed by our rules, and it contemplates approving or rejecting the stipulation that's proposed before you, and there is a motion on it. And so the resolution of the motion prior to contemplation of additional exigencies is probably...
Well, I think we could temporarily postpone the matter, not for long, because we're almost at the end of our agenda.
Can we debate his motion?
We could debate.
For comment,
Let's do it.
whenever.
Okay, Commissioner Carbajal.
Thank you very much. So I respect the argument towards consistencies, And particularly in those areas that we have discretion on, I would strongly recommend that. And it's clear that we are moving towards more stringency, and that is consistent, incidentally, with what the citizens of this state voted with Amendment 12. But I think that, you know, one of the things, I'll make two comments in particular to this case and to the discussion that was before. Had we not had those other comments before, this case might have proceeded and might not have. I'm not going to presume how you would have voted. But I do find a distinction between this and the prior case. They are not consistent. A clerk of court that does not disclose all the assets is not completely identifying what they may be swayed for or how they would be moved. In this case, we have the advocate's recommendation that there was, as I thought I heard it represented at least, cooperation, no malice, no intent to hide facts. And the second comment that I'll make, and why I support this, is we have often turned to the advocates and asked them, do you feel comfortable with this? And when they say no, you know, we support them. In this case, the advocate, I thought, represented fairly that she thought that this was a fair proposal as it stood on its own. And I want to support the advocate in that sense. The consideration of how much goes into these negotiated items, not the items that we're determining, but the negotiated items, are about how much it goes to the case, how long it's going to protract, what's going to be required in terms of the assets. And I appreciate the general conversation that's been going on about stringency, but I'm looking at this case as it was negotiated, as it was presented, as the advocate advocated for. And I'd support that. I'm willing to lose on it, but I just wanted to make sure that we had these discussions and weren't just holding one individual that was cooperative against another individual.
Further discussion, Commissioner Lesnoff.
Yeah, I looked at this proposed settlement, and I too actually thought it might be a little light in comparison to actually the case you mentioned. And I agree with all the comments regarding stringency, accountability, et cetera. However, I also need to take into consideration, or I do take into consideration, the work that the advocate has done. And so if it was something that I thought was way out of line, way too low, I would certainly not have seconded or supported. That it might be a little low, to me, I've got to give some weight to the advocate and to the work done, and recognizing that a couple more $100 here or there is probably not that weighty of an issue, especially when compared with having to move forward, either do a renegotiation or go to DOA. So that's where my second came from, and why there was some reluctance, because I do think it was a little light.
Is there further discussion? Commissioner Wallman?
So, well, okay, so we agree it's light, and I think we also agree that we should have some type of consistency, and I agree with Commissioner Carvajal about that. So I look at a county commissioner a little differently than I look at a clerk of a court. Clerk of a court handles ministerial things, and so what their specific holdings are don't really make a difference in their function, the job that they do. They have rules. They bring money in, they pay money out, they collect money from the courts, they do all that kind of stuff, they hold the records. Doesn't really matter what their personal feelings are. In fact, we probably should just all have nonpartisan clerks of the court and all that. But that being said, that's a whole other thing. But a county commissioner is somebody out in the public, makes themselves a public figure, and they ought to have full and complete disclosure of their assets and of their income. This is a situation here where we don't have a full disclosure of an income. And I think it's important, and is it, I guess, is it personal to me because I'm a resident of Broward County? I guess it is. I look at it and I say, you know, I want to know what my public official, my county commissioner, does. Where do they make their money? Do they make their money? And do they disclose it? And so this is different. It's not just whether it's $250 agreed to, or $500 that we think, or $1,000 or $1,500 or whatever it is. But I think we have to have that consistency, and I don't see that here. Now, I'm prepared, as Commissioner Carvajal is prepared for his motion to go down. I'm prepared for my opinion to not be in the prevailing side, but I do think that this is something that should be higher and that we should reject.
So, Mr. Chair, just real quick, to my statement earlier, or question earlier, if it does get voted down, will there be an opportunity for the parties, since they're both here, to go back out and come back, or does it have to come before the commission 6 weeks from now?
Well, I think the answer to your question, correct me, Carolyn, if I'm wrong, but if we vote it down, they are here, they have the ability to go out and come back. The problem is we have one additional item on our agenda, and we're going to adjourn. And so they would have to come back very quickly. If they want to do that and come back and say we would agree to a higher amount, then I assume we could consider that as an amended joint stipulation, and we could vote on it. But I don't think the next item's going to take us very long, and we're going to be adjourning and going into executive session. So that's the answer to your question. Otherwise, they would have to come back at Mr. Ottenott?
Ma'am?
Perhaps I could clarify.
General Counsel.
And provide some historical perspective from prior. This is unusual. The rules contemplate accepting or rejecting the proposed stipulation in writing before you. I note that it's not just a monetary stipulation, but the stipulation contemplates other, like a dropping of one of the charges as part of the contemplation. If it is rejected, it no longer exists. So whatever comes back before you, either in 10 minutes or at the next meeting or whenever, it will not be an amended version of this stipulation. It will be a new stipulation provided by an ora tennis motion for your contemplation, and it will be orally articulated in this juncture. This has very rarely happened, but it has happened before, but that's how it would transpire. You would, if this is rejected, this has to be approved or denied, and what will then come before you will be a new presentation of a new stipulation for your contemplation, if it so manifests itself.
Commissioner Lesnar.
I have to question notice provisions. The public has been noticed of this particular joint stipulation. I don't know how we survive an issue with respect to noticing and approving a brand-new stipulation that the public has not had the opportunity to see. And for that reason, I could not support being involved in such a vote due to the lack of notice of the new.
You are absolutely correct. Our rules do allow for written responses, as have been provided here, one by the complainant. And it does afford the complainant, in the normal course, a full due process ability to respond in writing. Although they can't converse with you regarding the stipulation in person, they do have the ability to provide a written response. That would not be possible here under this expedited contemplation, which is not beneficial to the process.
Okay, I think where we are is we got to vote up or down on the joint stipulation. If we vote down on it, certainly the parties can renegotiate a joint stipulation and bring it back to us, and that's what we're going to do. But I'm going to, as a matter of courtesy, give Mr. Ottenott an opportunity to make a statement, which he apparently wants to do, having approached the podium.
Thank you, Mr. Chairman. Obviously, my presence and Commissioner Holden's presence here clearly show the importance of this matter and respect for the state of Florida law on ethics. I came here for the previous hearing. We have worked diligently, we have worked hard, respectfully with the staff to ensure that we comply with the requirement of the law. When we received notice of this complaint, we immediately went into action, talked to the investigator, disclosed every single information that they wanted. We respect this body. We respect the state of Florida. Obviously, there was an inadvertent mistake in terms of rental income. It was quickly corrected. And in conclusion, we support staff recommendation. I hope this body supports staff recommendation also. Thank you.
Thank you, sir, for those remarks. All right, is there any further discussion before we take a motion on Commissioner Carvajal's motion, take a vote on Mr. Carvajal's motion, which is simply up or down? We accept or reject the joint stipulation. If we accept it, then it's done. If we reject it, then there can be some future movement to bring it back to a future meeting.
My recollection and my notes reflect that Commissioner Carvajal's motion was to approve it, and it was seconded by Commissioner Lesnoff.
Okay? All right. Any further discussion before we vote?
Sir?
Commissioner Meggs.
You know, everybody knows what to do with the bull except the person that has it by the horns. And I think probably with what we've talked about and discussed here today, that we probably ought to approve this. I will vote for the motion to approve this stipulation. And I think we've sent a message a little bit to the world and the public through our discussion that we'd like to be a little tougher, but we don't have to be mean, and we can get this resolved this morning, and they won't have to come back. So that's my statement.
Are there further comments?
Just one further, just because, Mr. Chair, thank you. I just want to make sure, I know it wasn't directed at me. I'm not doing this to be mean, okay? This is not, I want to be consistent, is all I'm looking at. This is not
And certainly we
personal.
understand that, Commissioner
Just-
Waldman, and I think we...
I didn't want him to think I'm a mean person or anything.
I was thinking about Commissioner Lesnoff.
I kept you guessing on this one. I seconded
But you
his
were looking at
motion.
me when you said it.
Yeah, I think we all agree that, and it's very, very difficult to have, you know, in the criminal courts, they have sentencing guidelines. And that's so that, you know, judges are relatively on the same playing field. We really can't do that here because there are so many factors. And as Commissioner, as Ms. Miller has pointed out, certainly the actions that a person takes to correct their wrong and to cooperate with the commission and all of that, certainly that is a factor that needs to be taken into consideration as opposed to somebody who just as mean as they can be and as obstinate as they can be all along the process. My personal thought is that in considering a penalty, it's not only what somebody does, but what they do about it. And I mean, we just had the Stewart case, you know, and an error was found, and as been said to us, the person immediately said, "I was wrong. I want to make it right," and whatnot. And those kind of things, I think, should weigh into it. And that's what Ms. Miller said to us about this particular case. So that's just my thought. Any further comments? All right, I'm going to call for a vote. All in favor of the Carvajal motion to accept or reject, say aye.
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 All nays.
No.
All right, there's one nay, and it passes. Thank you, Mr. Holness and Mr. Ottenott, for your help and your consideration. All right, that takes us to consideration of advisory opinions, and I'm going to call on Gray. We have just one advisory opinion on the agenda, and just to remind everybody, as you know, the public says that or the law says any public officer, candidate, or public employee of Florida who's in doubt about the applicability of the disclosure laws or standards of conduct they can come to us and ask for an opinion. And this is a good thing because it not only answers their particular question, but it sets some precedent so that others can see how the commission has ruled on various items and can be governed in their conduct accordingly. Let me ask, is the requester here or anyone representing the requester?
Thank you. I'm Vicki Shirley, General Counsel for the Board of Governors, and I'm representing Mr. Slaughter.
Thank you very much. Greg?
Mr. Chair, for disclosure?
Yes.
Thank you, Mr. Chair. Mr. Szilagyi is an acquaintance of mine. I have worked with him in the past on certain issues, but more importantly, FPL is a board member of Florida Tax Watch, the organization I work on. I do not personally inure any more or less the decision in here, but I wanted that on the record. I do intend to participate in the discussions unless advised not.
Okay. Anyone else?
Mr. Chairman.
Yes, sir.
Mr. Chairman, Mr. Szilagyi is a person who has contributed to my campaigns for office and to campaigns that I've solicited him to contribute to. I do not have any business relationship with him. Those solicitations and contributions occurred more than 6 years ago. I don't consider him an acquaintance beyond that, but I want to disclose it and state that I don't believe it will have an effect on my participation.
Further comments, Mr. Waldman?
Well, as long as we're making disclosures. I wasn't going to disclose anything because I didn't think it was necessary, but based upon the fact of what Commissioner Gates has stated, I certainly have been a recipient of campaign contributions from FP&L. I've met Mr. Szilagyi several times. We are not acquaintances and certainly will not impact my decision-making or discussion in this matter.
Further comments? Gray, you're recognized.
Thank you, Chair. Commissioners, as you can tell, this is a fairly lengthy opinion with a lot of facts to wade through. My hope is that once we all understand the facts, you'll find the legal analysis to be fairly straightforward. The request is coming from a member of the Board of Governors for the State University System, and it concerns the Board of Governors being asked to approve a project agreement being put together by UF. Now, UF is currently engaged in an ITN to select a developer to build a new energy plant on its campus in Gainesville. The project would also require whatever developer is selected to build some distribution pipes to run water away from this new energy plant and to construct a new substation to run electricity out to the plant. So there's several different facets to the project. Now, the key thing to zero in on here is that from what we've been told, UF is handling the ITN on its own without any input or involvement from the Board of Governors. And from what we've been told, once the project is up and running, UF and whichever developer is selected are going to be overseeing the construction and the operation of the energy plant and the other parts of the project on their own without any oversight from the Board of Governors, except for making occasional progress reports. You know, obviously, if there's material changes that need to be made to the project agreement, those will have to come before the board as well. But by and large, what I want to focus in on here is that UF and whichever developer is selected will largely be handling the project on its own once the project's approved. The one caveat to all that is that once the ITN is complete, the Board of Governors will be asked to approve whichever developer is chosen by UF. So while the board overall has a limited role, there's no sugarcoating the fact that it does play an important part in this process and that it has to approve the developer that UF chooses and the overall project itself. And that way, I guess you could say it functions like a gatekeeper, letting them in the gate. But from what we've been told, that'll be handled in just one vote. And as I've described, it'll more than likely be the board's main role and only role in this process. Now, this inquiry is being brought because one of the companies that's advancing through the ITN with UF, it hasn't been selected yet, it's just advancing through the ITN, is called Gator Campus Energy. Gator Campus Energy is an energy consortium comprised of 3 equal partners. It appears to have been formed in hopes of securing this energy project contract at UF. One of the partners in Gator Campus Energy is called DG Concession Holdings. This is where it gets a little bit complicated. DG Concession Holdings is owned by several other companies, all of which are subsidiaries of NextEra Energy. And NextEra Energy, the parent company here, is a very large publicly traded company that provides energy services throughout the U.S. and Canada. Now, NextEra obviously has many subsidiaries besides DG Concession Holdings. I checked the SEC website, and they have data from a few years ago indicating that it may have as many as over 1,000 subsidiaries. Now, one of NextEra's other subsidiaries, and it is a very large one, no doubt, is Florida Power and Light. This question is coming before you because the Chief Executive Officer of Florida Power and Light is a member of the Board of Governors, and that means that he may be asked to approve a project agreement involving a sister subsidiary of his company if UF selects Gator Campus Energy as its developer, because he may be asked to approve then a project agreement involving DG Concession Holdings. So let me run down the highlights of the facts again. You got a Board of Governors member potentially being asked to approve a project agreement involving a company that is a sibling subsidiary of his employer. They share the same parent company, NextEra. A couple other facts to note. The board member in question apparently has no ownership or any interest in Gator Campus Energy or in DG Concession Holdings. His company, his employer, Florida Power and Light, will also have no involvement in the performance of any project agreement with UF, won't be paid any compensation no matter which developer is selected by UF. We've been told that Florida Power and Light can't even provide services in that area of the state. Now, that being said, the board member does have some stock ownership in NextEra, which again is the parent company of both Florida Power and Light and DG Concession Holdings. We've been told that stock ownership in NextEra equals about a less than 0.0001% interest, because NextEra has over 1 billion shares of stock in it. So those are the facts. They're fairly complicated. Hopefully the legal analysis will be a little bit more straightforward. There's 3 main statutes that the draft opinion looks at. The first is section 112.313, subsection 3. That's going to be triggered if a public officer in their public capacity is acting to purchase realty goods or services from a business entity where he's an officer, partner, director, or proprietor, or has a material interest, which means ownership of over 5% of that business. Now here, the only parties to a potential project agreement will be UF's Board of Trustees acting on behalf of the university and Gator Campus Energy. This board member has no interest or officership in Gator Campus Energy or even in DG Concession Holdings, which again is one of the partners in Gator Campus Energy. Florida Power and Light, where he's employed as a CEO, and NextEra Energy, where he owns stock, are not going to be parties to this agreement. So mechanically speaking, it doesn't look like the elements of section 112.313 subsection 3 are met here, because he's not an officer and doesn't have an over 5% interest in any business entity selling services to his agency. Now, the next statute is section 112.313 subsection 7A. And as you know, that has 2 parts to it. First part is fairly mechanical. It says a public officer can't be employed by or have a contractual relationship with any business entity conducting business with his agency. Now, importantly, the Commission has always interpreted that term in the statute, business entity, as recognizing a clear separation between different subsidiaries, one from another, as well as between subsidiaries and their parent companies, one from another. That reflects corporate law. So that means that a parent company, each of its subsidiaries, are separate and distinct business entities for the purpose of the statute. So here, this board member is employed by Florida Power and Light, and he has a contractual relationship with NextEra, the parent company, because he owns stock in it. But neither Florida Power and Light nor NextEra will be doing business with UF or the Board of Governors if this project agreement is approved. It'll just be Gator Campus Energy that'll be doing business with the university, and the board member doesn't have any employment or contractual relationship with Gator Campus Energy or any of the partners in Gator Campus Energy. So again, mechanically speaking, the elements of the first part of the statute are not met here. Now let's look at the second part of section 112.313 subsection 7A. This is more broad. It says a public officer can't have an employment or contractual relationship that could create a continuing or frequently occurring conflict with the performance of their public duties, or that could impede their ability to discharge their public duties. Now, the Commission traditionally approaches this part of the statute by looking at whether a public officer has an employment or contractual relationship that is significant enough that it could tempt them to compromise their public duties. And that requires the Commission to also look at the nature of the public officer's duties. You know, how are they going to be involved in this particular transaction? Now, I'm recommending for several reasons that you don't find a prohibited conflict under this part of the statute either. First, as I've said, the board member has no involvement with Gator Campus Energy or DJ Concession Holdings, which will be the parties actually performing the agreement if Gator Campus Energy is selected. Second, it doesn't appear the board member's employment with Florida Power and Light could tempt him to compromise his duties as a Board of Governors member, because Florida Power and Light won't be involved in anything to do with the UF project, won't be experiencing any compensation no matter which developer is selected, can't even provide services in that area of the state. Third, let's look at his ownership in NextEra Energy, his stock in the parent company. Now, one of NextEra's subsidiaries, DJ Concession Holdings, is obviously going to benefit if Gator Campus Energy secures this project. But remember, the board member here has a less than 0.0001% ownership interest in NextEra. It's not very substantial compared to the scope of the company. And even then, the Board of Governors, as I laid out, has an important role in this process, but it's fairly limited. All it's going to be asked to do will be to approve the project agreement with whichever developer UF selects. That'll be the extent of his role. So given his limited stock ownership in the parent company and the board's limited duties, my recommendation about the second part of the statute is that any affiliation he may have with NextEra, the parent company, will also not trigger a prohibited conflict. Now, that all being said, I do think there is a voting conflict here under the third law I looked at, Section 112.3143, the voting conflict statute. Voting conflict law says a voting officer can have a conflict if the measure will bring special private gain or loss, economic benefit or harm, to a parent organization of their principal, meaning a parent organization of their employer. Now, obviously, a vote to extend this project to Gator Campus Energy by the Board of Governors could have some trickle-down effect on NextEra Energy, the parent company, because that means that one of the partners in Gator Campus Energy, DJ Concession Holdings, is a NextEra subsidiary. Anything benefiting that subsidiary conceivably could affect and benefit the parent company. Because NextEra is also the parent company of the board member's separate employer, Florida Power and Light, it looks to me then that he'll have to comply with the parts of the voting conflict statute that apply to state officers, because this will be a vote that could have an economic effect on the parent organization of his employer. That means under the law about state officers, he can vote, but he'll have to fully disclose his voting conflict before jumping in any discussion about the vote, and he'll have to file the Form 8A voting conflict memorandum within 15 days of the vote. So I do think he'll have to treat this as a voting conflict if Gator Campus Energy is selected. I know my comments here have been lengthy. I apologize for that. This is my best recommendation based on the facts that were presented to us, but I do want to note there is language in the draft warning the board member that in addition to the laws I just went over, that he may have a problem under the misuse of public position statute or the disproportionate benefit prohibition in the state constitution if he were to abuse his position in any way to coerce an agreement going to Gator Campus Energy. So that language is in the draft. I present the draft now for your review, and I'm happy to answer your questions. And I know Ms. Shirley is also available to answer your questions if you have anything that she could better address.
Thank you, Gray, for that presentation. Are there members of the commission who would like to ask questions?
Mr. Chairman, I have a question for Ms. Shirley, if that's appropriate.
Ms. Shirley, you're recognized.
Ms. Shirley, thank you for bringing this matter to us. You've heard, and I'm sure I've read and been involved in the development of this opinion. Do you have any comment on it? And do you have any comment on how you believe the trustee in this matter will react with respect to the declaration of a voting conflict?
Thank you, Commissioner Gates. Yes, we fully support the staff's opinion, and Mr. Szilagyi is certainly prepared. We have always been prepared for him not to even participate in the discussions related to this project.
Thank you, Mr. Chairman.
Thank you.
Thank you, Ms. Shirley. Are there further questions or comments, Ms. Lesnoff?
Just want to say, nice work, Gray.
Very nice work.
Well done.
Yeah, it was very well done. Commissioner Wallman.
Just one other disclosure I guess I didn't make is that I am a proud Florida Gator. So this has to do with this. But that will not impact my decision.
His vote only
here.
counts for half, is that what we are?
Well, they need all the power they can get down there. All right, further questions, comments? Do I hear a motion, we approve the draft opinion?
Second.
Commissioner Gilzine, is there a second?
Second.
Commissioner Wallman, is there discussion?
Great job, Greg.
Yes. Yes, that's very well presented. Congratulations. All in favor, say aye.
Aye.
All opposed, like sign. Thank you. That now takes us to the almost the end of our agenda. The first thing is the chair's report, and I just have a couple of items. One, I just want to thank the commissioners for electing me as chairman. I'm honored that you have designated me, and I look forward to being your leader during the coming year. Secondly, since becoming chair, I have been working much more closely with our staff. And I just want to tell you, commissioners, how well-tuned our staff is. As you know, this is my third time on the commission, and I can tell you we have the best staff, not only in their qualifications, but their working relationships that we have ever had. Carrie has done a wonderful job at retuning some things and doing some restaffing. Caroline is doing an excellent job as our legal counsel, and I just want you to know that we're in good hands. I've also been very involved with our legislative program over the last couple of months, and we're proceeding nicely, and Carrie will give you some more of the details, but we will know a week from today exactly where we are, and frankly, we're kind of on hold because we don't really know how to proceed. I hope, by the way, that you all took note of this that was in your packet, part of which will be inaccurate as the legislature changes next week with the law, but it would appear that we are going to delay electronic filing for a year. We did what we did because the law said we had to do it, and the staff has done a yeoman's job of getting us there, and we're ready to launch. But there is a general feeling in the legislature that, and I don't disagree with it, that if we're going to launch something like electronic filing, it's probably better to do it in a non-election year than in an election year where we have dozens of additional filings for people who've never done it before, and I think it will go more smoothly. It will give us an opportunity to fine-tune some things, and so I think that's where we're heading, but we will know next week. And that's my report. I'm going to turn to our executive director to give us her executive director's report and combine that with a legislative update.
Thank you, Mr. Chair, and thank you for those comments about the staff. I can agree they're pretty fantastic to work with. To that end, just a couple of brief comments in relation to the executive director's report related to staffing. We recently hired Rachel Campbell. She's here with us today as a new part-time clerk in our office. We are extremely glad to have her on staff, and she is already contributing and being very helpful to the work that we're doing. And as I understand it, in the Attorney General's office, the administrative assistant to Buff and Melody retired in December, and Buff and Melody have now added someone to their staff, and I want to defer. Buff, would you like to introduce Ms. Morgan?
Thank you. This is Alexandria Morgan, and
we're so glad to have you. Welcome. Trial by fire. So, and just one quick thing, kind of a kudos to staff that we received. It might not surprise you one bit to know that oftentimes when citizens call our office, they are not happy. And so our staff talks a lot to the citizens of Florida regarding things that they're most unhappy about. But sometimes they turn into fans after they talk to our staff. And there was one particular citizen who called to express some consternation with regard to some financial disclosure filings, but then expressed to Caroline his deep and abiding appreciation to the knowledge and responsiveness and helpfulness, in particularly identifying Millie, who's in the back of the room, and Kiana, who has come to the meetings before but is currently back at the office. So I just wanted to recognize them in the good work that they do. Moving on to legislative report, which will also meld into electronic filing report. As the chair tipped his cap to, I wanted to let you know that House Bill 7001 and 7003 related to the implementation of the lobbying provisions in Amendment 12 have passed the legislature with an effective date of December 31st of 2022. There's a House Bill 7067 that's passed through all of its committees in its second reading in the House. It has provisions relating to ethics training. It contains a part of your recommendation relating to voting conflicts, make some technical changes to executive branch lobbying laws. Also contains the recommendation relating to the conflicting employment contractual relationship section. Does away with some grandfathering provisions such as statute of limitations for 5 years related to collections of automatic disclosure fines in terms of if that person separates from employment of office, and also contains the Commission's recommendation regarding the ability to dismiss a lobbyist audit matter at any stage of the proceedings if the public interest is not served by proceeding further. Beyond that is on second reading. Also on second reading is House Bill 301, which has now passed all of its committees. That was the bill containing your recommendation relating to enhanced financial disclosure filings for city commissioners and mayors, village and town council members, and mayors filing a Form 6 instead of a Form 1. That seems to be was the most likely candidate to be amended to match Senate Bill 510. Senate Bill 510 originally contained the same provisions regarding enhanced financial disclosure filings. It was amended to also include city and county managers filing a Form 6. Also to note, when it was amended recently, it contains language that require members of the Florida Elections Commission as well as the Florida Commission on Ethics to file a Form 6 instead of a Form 1. It also would revert Form 6 filings back this year to paper only. As we did not promulgate forms for this year because of electronic filings, we would need to do that subsequent to it passing the legislature and the governor signing it into law. It would become law upon signing by the governor. We would do that potentially via emergency rulemaking, and the bill does contain language to allow us to do that. Significantly, it changes the law back also to allow for income tax returns to be filed in lieu of specifically listing income. Also allows for uploads of any other supporting documentation deemed appropriate by the filer, and pushes the e-filing dates to January 1, 2023 for Form 6 and January 1, 2024 for Form 1. This was important because the system as currently programmed does not allow for the filing of an income tax return as a part of someone's filing. That would have to be done via upload. Those things could not be done in time for this year's filing season. There were a number of considerations in relation to time. It didn't matter how many people we'd add. We did not have the time to do it. We also want to make sure that we deal with any type of security concerns for uploads. So, as a result of the possibility of these substantial changes to electronic filing, I opted to decide not to send the wholesale invitation to register to Form 6 filers on March 1, as we had originally planned to do. Instead, we provided those filers with an email letting them know that there were things happening in the legislature, potentially affecting e-filing in this year, and that we would update filers after we were certain as to the impacts of any decisions made by the Florida legislature. So it's been a busy few weeks. We are on pins and needles awaiting the policy decisions of the legislature, and I am eternally grateful to the work of this commission, particularly Chair Grant, Senator Gates. I've heard from many of you as well offering to help with what's going on, and Senate Bill 510 is in messages with the House, and we will see what they will do. And so that concludes my remarks. If anybody has any questions, I will endeavor to answer them.
Senate had sorted out, it was a kind of a mess.
I just have a question, and along with the theme of consistency that I've been trying to follow today. When you mentioned the Elections Commission and the Commission on Ethics filing a Form 6, my understanding was only elected officials filed a Form 6. Am I incorrect in that?
Elected constitutional officers do file the Form 6. There are a few other boards, I believe not elected, who file Form 6. Caroline, I know you have the law pulled up there. Would you like to?
That is correct. Section 112.3144 specifies in subsection 1 who are the officers who are required to file. You are very correct that the vast majority of them are elected public officers. However, it does not currently include elected members of city commissions. For example, they file a Form 1 currently. The proposed legislation at SB 510 would change that. Also, members of expressway authorities, transportation authorities, bridge authorities, toll authorities, those individuals may be in an appointed capacity. And governing bodies of large hub commercial airport service, blah, blah, blah. And I'm not sure how those guys get on there, gals and guys. Perhaps they are appointed, but it does articulate currently that it is the highest echelons of public service that merit such a disclosure, and it does propose, for the purposes of SB 510 at least, that that would include both elections commissioners as well as commissioners of the public, of this body itself.
So it raises us to those highest echelons, I guess. I mean, I filed it for a long time, but it just doesn't seem appropriate. That's what the legislature wants to do.
Are there further questions of our executive director? That brings us to the end of our printed agenda. Are there any other items or comments that any member of the commission wishes to make?
Mr. Chairman, just to thank our executive director for the careful and effective way that she has tiptoed through the legislative minefield. As you know, her first time out as executive director, I think she's done extraordinarily well in understanding the legislative process and in not pulling fire alarms that inexperienced people might pull at the wrong time. I think she's acted like a real master of the process, and I think that you never know. Nobody's life, liberty, or property are safe, until the legislature goes out of town. But I believe we're going to do all right, and I believe that a lot of that has to do with the good counsel that our executive director has provided to staff members in the House and the Senate about the consequences of various kinds of actions that well-meaning and concerned legislators have been contemplating.
Well said, and I would totally agree with that. Are there further comments or items for the commission? Not appearing. Commissioner Wallman moves that we adjourn. It is It is now 20 minutes of 11. We will start the executive session straight up 11 o'clock.